Hello and welcome to Legal Briefs. Today we pay tribute to judges who have gotten just a little bit creative in their opinions. Judges, especially appellate judges, are known to be pretty staid. You typically think of them as dour old attorneys with little or no sense of humor. Take for example the judge in William T. Moore v. the State of Washington. In the Moore case, an inmate filed a civil rights violation action against the state. In fact, the inmate had filed numerous civil rights violation lawsuits against the state and was apparently spending more of his time in prison drafting strange and unusual lawsuits and motions than doing anything else. However, he took it a little too far in this case when he filed a motion with the court titled Motion to Kiss My Ass, in which his desired relief was to kiss my goddamn ass, sorry mother effer you. Even the cussing wasn't grammatically correct. So the judge, handed the potential for comedy gold in drafting his opinion, instead spent pages and pages to dryly recite the inmate's abusive process, and then at the end hit him with monetary sanctions before he would be allowed to file any further lawsuits. Boring. But let's take a look at the decision by Judge Kent in Bradshaw v. Unity Marine. This was a fairly typical appellate issue as to what statute of limitations applied. Apparently, Judge Kent was not impressed by the substance of the lawyer's briefings on the case, or as the judge better put it, both attorneys have obviously entered into a secret pact to draft their pleadings entirely in crayon on the backsides of placemats in the hope that the court would be so charmed by their childlike efforts that their utter dearth of legal authorities in their briefing would go unnoticed. Ouch. Glad I wasn't one of those attorneys. But not all legal writing is that pissy, and my favorite example of nicer, happier legal writing is an opinion written by appellate Judge Gillis out of Michigan. The issue before Judge Gillis was whether the plaintiff could sue a negligent driver for damage to his property. Not damage to his car, but damage to a tree that was on his property. The trial court found that the plaintiff could not sue due to the state's no-fault law. Judge Gillis upheld the ruling, but wrote his opinion as follows. We thought that we would never see a suit to compensate a tree, a suit whose claim in tort is pressed upon a mangled tree's behest, a tree whose battered trunk was pressed against the Chevy's crumpled crest, a tree that faces each new day with bark and limb in disarray, a tree that may forever bear a lasting need for tender care. Flora lovers though we three, we must uphold the court's decree. And there you have it in almost perfect iambic pentameter. Well done, Judge Gillis, and thank you for watching.